Hi comrades, yours Kayveeyes. The DOPT exhibited in the website recently about the redressal of grievances filed by the government servants. It is a very important compilation that should be downloaded and should be kept by all the officials for reference and also for record. The crux of the compilation: if individual has not received a reply within 1 month, he can ask for an interview with the next higher authority. Suppose if you are making a representation and you did not get a reply from the concerned officers, in such situation, you can seek an interview with the next higher authority stating that you did not receive any letter for your representation, and that should be considered by the next authority. Such officer should immediately take action without any delay. This is a provision which can be used by all of us. Representation against the orders of immediate superiors should be dealt with expeditiously as possible. Those representation should also be considered within 1 month. That such representation that should also be considered within 1 month. Any representation that should be disposed within 1 month. The time limit is not applied in case represented again after the disposal of earlier representation on the same subject. There is a provision that once one representation is rejected, the official can make subsequently 3 representations with additional points he can submit for 3 times. In such cases, the time limit of 1 month is not applicable, and after the disposal of the earlier representation, they can submit some representation for review. But however, the time limit is not applicable in such cases. Appeals and petitions receive prompt attention, and that should be disposed within a reasonable time. All appeals and petitions that should be disposed prompt attention and disposed within a reasonable time. If those could not dispose within 1 month, an acknowledgment or interim reply should be sent to the official. This is as per OM dated 2012-1968. If the representation or appeal that could not be settled within 1 month, an acknowledgment or at least some interim reply that should be sent to such official, this everybody should note for making proper representation. Submission of representations bypassing the channel of communication can be treated as unbecoming of a government servant. We should not violate the channel of communication. If violating the channel of communication, that all forms of communications, including email, public grievances portal, etc., that will be treated as unbecoming of a government servant. This is as per OM dated 6/6/2013 and also 31/8/2015, in which they included all the emails and public grievances portal, etc. So accordingly, all communications that should be made through proper channel only by the officials. Whether he can send the advance copies of representation, which does not show that all means of securing attention or redress from the lower authorities tried and exhausted, should be ignored or rejected summarily. Any advance copies received at the higher officers, that should be rejected or ignored unless there is sufficient reason that the lower authority has not given any attention or redressed the grievance of the official. Only such cases only the advance copies of the recommendation that should be considered. If the advance copy of the representation exhibits the efforts or trial or exertion, it should be examined. It can be referred to the lower authority for report and comments. Even in such cases also, such advance copies representation thus should be forwarded to the lawyer authority for his report and also the comments, and thereafter only that can be considered. Ordinarily, there is no justification for passing any orders without ascertaining the comments of the appropriate authority. This is as per 34/1952 orders. No notice should be taken of a representation submitted by a relative on service matter. If relative submitted any representation, that need not be considered, that is violation of conduct rules also. The only exception that in the case of death or physical disability and the official could not represent, in such cases the relative can represent. This is as per OM dated 19/9/1963. Disciplinary action may be taken against those violating these instructions as per OM dated 1/11/1999 and 6/6/2013. Government servants can seek redress through legal, for which no permission is required. They can go to CAT, they can go to High Court, they can go to Supreme Court, for which no permission is required as per 26/11/1963. These are all the salient features contained in the compilation of Redressal of Grievances filed by the Department of Personnel and Training in its website. It is very important. Everybody should understand when the representation is not disposed in time, they are having ample chances to represent again and again. Even when representation is disposed, he need not think that is the closure of the subject. He can represent to the next authority, or even he can represent to the same authority further twice or thrice with new points, with new submission. That should be entertained. With this, I am concluding. Thank you very much, comrade. Meet again.